So, good day to everyone. This is once again Attorney Michelle, your instructor on criminal law and jurisprudence. So, in our previous discussions, we've actually highlighted several concepts of criminal law, especially in the development of crimes and the stages of execution. So, if you can still remember, we've discussed that generally only external acts are punished under criminal laws because internal acts such as mere ideas in the mind of a person are not punishable even if had they been carried out they would constitute a crime. So let's always remember, right, that only external acts or acts which would produce an effect in the outside world are punishable under criminal laws. That is the general rule. However, the revised penal code also provides for several exemptions to the general rule. So we've also discussed those articles pertaining to conspiracy and proposal to commit a crime. So again, the general rule is that conspiracy and proposal to commit felonies are not punishable. However, under the revised penal code of the Philippines, conspiracy and proposal to commit treason, rebellion, and sedition are already punishable. So those are the three crimes or felonies within which even at the conspiracy and proposal stage, they are already punishable. So during our previous class, we've already had the opportunity to discuss the definitions, the elements, and the requisites in the commission of treason, rebellion, and sedition, and what constitutes conspiracy and proposal to commit treason, rebellion, and sedition. So I hope that you will never forget those concepts, especially that they will be included during our exams. Likewise, during our discussions from previous meetings, we've already had the opportunity to discuss some of the salient provisions on the penalties or the imposable penalties under the revised penal code. So today, once we start studying more about the penalties and also the specific provisions under the revised penal code, we will continue to revisit what are the type of penalties that are actually imposable, especially for grave offenses, less grave offenses. We've already began with light felonies, and then now we are going upwards according to the provisions of our criminal law. So let's begin. We are now actually on Article 9 of the Revised Penal Code. So I am sharing my presentation with you guys. So for today, our topic mainly would focus on Article 9 and Article 10. And as I have previously mentioned, all the topics that we have discussed until Article 10 will be included in the exams that I will be administering on Friday. So we will be having our prelim exam on Friday. So now let's discuss Article 9. So Article 9, grave felonies, less grave felonies, and light felonies. So grave felonies are those to which the law attaches the capital punishment or penalties which in any of their periods are afflictive in accordance with Article 25 of this code, while less grave felonies are those which the law punishes with penalties which in their maximum period are correctional in accordance with the above mentioned article. Lastly, light felonies are those infractions of the law for the commission of which the penalty of arresto menor or a fine not exceeding 200 pesos or both is provided. So let's examine each provision of this specific article. Let's start with, but before that, let us first discuss the penalties, the imposable penalties under the revised penal code. So we will also be able to imagine and also to be able to cross-check which penalties are actually afflictive, which penalties are imposable on less grave penalty. So let's first try to examine and try to remember those penalties and what do they entail. So we have the penalty of destierro. I will discuss this a little later as we go along with our discussion on this specific provision or of Article 9. We will also try to remember, okay, arresto menor is 1 day to 1 month of imprisonment. Arresto mayor, 1 month plus 1 day to 6 months. Prisión correccional is 6 months plus 1 day to 6 years. Prisión mayor, 6 years plus 1 day to 12 years. Reclusión temporal is 12 years plus 1 day to 20 years. Reclusión perpetua, 20 years plus 1 day, 40 years. And we also have here death penalty. But we've already discussed in prior meetings that currently our courts do not impose the death penalty by virtue of a special law. So we will also discuss that law today as we examine the provisions of Article 9. So let's first discuss the first provision or the first paragraph of Article 9. Grave felonies, less grave felonies, and light felonies. Grave felonies are those to which the law attaches the capital punishment or penalties which in any of their periods are afflictive in accordance with Article 25 of this code. So, let's first discuss the first sentence, okay? The first provision to which the law attaches the capital punishment. So as I mentioned earlier, death penalty is still provided for under the revised penal code. It was not actually amended. It was not taken out. However, we do have a special law which suspends the imposition of death penalty to those persons who actually committed a crime punishable by a capital punishment, which is death penalty. So here in for grave offenses, no, because grave offenses are those which are punishable by a capital punishment. So all crimes under the revised penal code or all other crimes under the special penal laws, when a capital punishment is provided, then that is considered as a grave felony. Likewise, number 2, or penalties which in any of their periods are afflictive. So although the word any is used in this phrase, when the penalty prescribed for the offense is composed of 2 or more distinct penalties, the higher or highest of the penalties must be an afflictive penalty. So there are instances actually that um, uh, the offense in itself provides for 2 or more distinct penalties. It doesn't necessarily mean that for a crime to be considered as a grave felony, that those 2 or more distinct penalties should be afflictive. What is necessary is at least one of those penalties is an afflictive penalty. So under the law, the afflictive penalties include reclusión perpetua, reclusión temporal, and prisión mayor. Okay? Under the law, afflictive penalties again, no, for purposes of emphasizing this provision, afflictive penalties include reclusión perpetua, reclusión temporal, and prisión mayor. So going back to our table of penalties, so those which are punishable by reclusión perpetua, 20 years to 20 years plus 1 day to 40 years. Reclusión temporal, 12 years plus 1 day to 20 years. And prisión mayor, 6 years plus 1 day to 12 years. right? So up to prisión mayor, this is still considered as an afflictive penalty. So take note of that, okay? So when we say afflicted penalty, we are talking from prisión mayor from 6 years from 1 day to 40 years. So if any of these afflictive penalties are included in the penalties provided for in a specific crime or felony, then that crime is considered as a what? A grave felony, because we also, even though it's not punishable by death penalty, the law still provides that those crimes punishable by afflictive penalties are still considered as grave penalty. So going back to my discussion on the death penalty, so as I've mentioned, the death penalty was not really removed from the revised penal code. What our lawmakers did is that what it prohibited the imposition of death penalty. So Republic Act 9346 Section 1, the imposition of the penalty of death is hereby prohibited. Accordingly, Republic Act number 8177 or RA 8177, otherwise known as the Act designating death by lethal injection, is hereby repealed. So remember our discussions before with the case of Leo Echegaray, wherein he was the first person administered with the lethal injection. So nowadays, this can no longer be done because courts are prohibited from imposing death penalty, even if such crime or some crimes are actually punishable by death or capital punishment. Republic Act number 7659, otherwise known as the death penalty law, and all other laws, executive orders, and decrees insofar as they impose the death penalty are hereby repealed or amended accordingly. So all those laws no, that impose the death penalty for certain crimes or felonies, the judge, even if the crime committed is punishable by death penalty, the judge handling such case cannot impose. So what will happen now if he cannot impose the death penalty to those accused who are already found to be guilty beyond reasonable doubt? So it is provided for in Section 2 of this law. In lieu of the death penalty, the following shall be imposed. The penalty of reclusion perpetua when the law violated makes use of the nomenclature of the penalties of the revised penal code, or the penalty of life imprisonment when the law violated does not make use of the nomenclature of the penalties of the revised penal code. So that's why I've discussed with you before, diba? Um, uh, Sometimes we get confused on the terminologies reclusion perpetua or life imprisonment. But take note, if the crime is defined under the revised penal code, what we use is the nomenclature under the revised penal code, which is, of course, includes the reclusion perpetua, reclusion temporal, prisión menor, prisión mayor. But if the crime is punished under a special penal law, sometimes they do not use the nomenclature used in the revised penal code. Instead, they use terms such as life imprisonment. But sometimes they are considered or necessarily considered as the same. However, it's just that reclusion perpetua is based on the revised penal code, while the penalty of life imprisonment is normally or usually or generally provided under special penal laws. Okay? So, Section 3, person convicted of offenses punished with reclusion perpetua or whose sentences will be reduced to reclusion perpetua by reason of this act shall not be eligible for parole under Act number 4180, otherwise known as the Indeterminate Sentence law as amended. So, while we go along with our discussion in the future, we will also tackle the Republic Act 4180 or the indeterminate sentence law. So from there, we will understand how the courts temper or decide on the penalty imposed on a criminal act, no? Depending on the, of course, depending on the nature of the offense itself, the mitigating circumstances, and of course also likewise the circumstances of the person who committed such crime. So we will also be tackling that in the future, but that is way ahead in our discussion because the indeterminate sentence law is always discussed together with the imposable penalties under the revised penal code. But don't worry, we will have an extensive discussion on this one once we reach the penalties and the imposable penalties for crimes committed. Okay, so we're already done with grave felonies. So just take note that grave felonies are those which are what? Punishable by capital punishment or penalties which in any of their periods are afflictive. When we talk about capital punishment, we're talking about death penalty. However, just take note that we have Republic Act 9346, which prohibits the imposition of the penalty of death penalty. So even if there are several aggravating circumstances for a heinous crime committed by a person, and death penalty really is available as an imposable penalty, the judge nonetheless cannot impose death penalty and may downgrade the penalty to reclusion perpetua or life imprisonment depending on the basis of the law of the law defining the crime or felony or offense committed. Okay, now let's go to less grave felonies. So less grave felonies are those which the law punishes with penalties which in their maximum period are correctional in accordance with the above mentioned article. So when the penalty prescribed for the offense is composed of two or more distinct penalties, the higher or highest of the penalties must be a correctional penalty. So example, a felony punishable by arresto menor 2 is a less grave felony because the higher of the two penalties prescribed, which is the Sierra, is a correctional penalty. Arresto menor is a light penalty. Okay, so let's examine what are correctional penalties. So, prisión correccional, arresto mayor, suspension, and destierro are all correctional penalties. So, correctional penalties will start from destierro to prisión correccional. So, revisiting our table here, so destierro, arresto mayor, to correctional, not including arresto menor ha, because arresto menor is a light penalty. So what is included in correctional penalties are prisión correccional, arresto mayor, and destierro. So if the crime committed is punishable by arresto mayor, prisión correccional, suspension, and destierro, they are all considered as less grave felonies. Okay, so less grave felonies is interconnected with correctional penalties. So, now let's discuss destierro. What is destierro? So, I'm not sure if you've heard about this, but destierro is also a penalty provided for under the revised penal code under special circumstances. So, destierro means banishment for only a prohibition from residing within the radius of 25 kilometers from the actual residence of the accused for a specified length of time. While it is technically not imprisonment, it is still a penalty imposed under the revised penal code of the Philippines. So what happens here is that the accused cannot live within within the 25-kilometer radius from the victim. The accused here will not go to jail, will not spend some years in jail, will not be imprisoned, but nonetheless, the accused here cannot live or reside within 25 kilometers from the residence or from where the victim is residing. Okay, so it's still a penalty. So he cannot go near the victim or the residence of the victim. So from what type of cases can destierro be imposed? So Article 247, death or physical injuries inflicted under exceptional circumstances. So if you've heard about the term crimes of passion and obfuscation, this is usually the penalty where given to an accused in such crime. So under exceptional circumstances. So what are these exceptional circumstances? So any legally married person who, having surprised his spouse in the act of committing sexual intercourse with another person, shall kill any of them or both of them in the act or immediately thereafter, shall inflict upon them any serious physical injury, shall suffer the penalty of destierro. So what is this case, right? So I actually want to show you a case on this one in the future, so we will discuss that as well. So what is it in here? Okay, so if a married person catches his wife or husband having sexual intercourse with another person, and as a result of his anger of about what he saw, and as a result of that, he either kills or causes serious physical injury to the husband or wife or the paramour, okay, the person whom the wife or the husband is having sexual intercourse with, they will not actually be imprisoned. So the accused here, the legal spouse who causes the death of either or both the spouse or the cheating spouse or and the paramour, he will not be put into prison. He will not be imprisoned. He will not suffer the penalty of imprisonment, but he or she will be required to live uh, outside of the 25-kilometer radius. Okay? Okay? If he shall inflict upon them physical injuries of any other kind, he shall be exempt from banishment. So just take note that we have serious, less serious physical injuries as well. So if it's not serious physical injuries, there are qualifications of serious physical injuries under the revised penal code. If the injury inflicted is not serious physical injury, then the spouse who committed or who performed the act of killing and also causing serious injury to the spouse and the paramour, then he will not be or he will be exempted from punishment. Okay? These rules shall be applicable under the same circumstances to parents with respect to their daughters under 18 years of age and their seducer while the daughters are living with their parents. So, for example, also, the parents got angry because someone seduced their daughter who is under 18 years of age, a minor, and while such daughter was living in their house, if the parents shall inflict or kill the seducer, they will not suffer imprisonment if found guilty, but will merely be penalized with destierro, which means that they will be required to live beyond the 50-kilometer radius from where the victims are residing. Any person who shall promote or facilitate the prostitution of his wife or daughter, or shall otherwise have consented to the infidelity of the other spouse, shall not be entitled to the benefits of this article. Because of course, at the end of the day, if you had consent to the infidelity, if you consented, or if you had an agreement with your wife that your wife will be engaging with, or your husband will be engaging with sexual intercourse or sexual relationships with other persons other than yourself, then that will not be the act that is defined in this article. So take note of that. If you consented to the amorous acts of your wife, or if you yourself has facilitated or promoted the prostitution of your wife, your spouse, or your daughter, then you cannot raise this as a defense and still be met. And if found guilty, you will still be meted or meted by the specific penalty provided for under the law, whether it be homicide or physical injuries. Okay? So there are exemptions on that. But if the spouse, having been caught off guard, having been surprised to see his spouse or her spouse in a sexual intercourse with another person, okay, and by reason of his anger or passion or obfuscation kills the spouse, and the paramour shall not be held liable for the shall be held still liable, but will be penalized for a different kind of penalty, which is now destierro. But just take note, okay, destierro is very specific to this type of crime punishable under the revised penal code, which is article 247, death or physical injuries inflicted under exceptional circumstances. Likewise, another provision under the revised penal code, article 334, concubinage, any person who shall keep a mistress in the conjugal dwelling or shall have sexual intercourse under scandalous circumstances with a woman who is not his wife, or shall cohabit with her in any other place, shall be punished by prison correctional in its minimum and medium period. So as I've mentioned before, for concubinage, also the concubine will be what? Will be charged for concubinage. However, the penalty of destierro will be imposed to the concubine, to the kept woman. Okay? But the husband who was guilty of concubinage will can be penalized with prison correctional. It is just the concubine, even though that both of them perform the same acts and may be held liable for concubinage. It's just that the concubine specifically shall only be penalized with destierro. So take note, only in Article 247 and Article 344 can destierro be what? Be given as a penalty. For all other crimes, they are already defined under Book 2 of the revised penal code. So we will try to revisit some of those crimes if we have time. We will try to see their definitions, okay, and the penalties, the imposable penalties that can actually be given for specific crimes. So because going back with our discussions, okay, criminal law is that branch of municipal law which defines crimes, treats of their nature. So now that's the nature of the crime, whether it is a grave felony, a less grave felony, or a light offense. So grave felonies, as you saw, has a different penalty or a higher form of penalty, while less grave felonies will also have penalties, but only limited to correctional penalties, while light offenses will also be punished by light penalties. Okay, next, let's go to Article 10. Article 10, offenses not subject to the provisions of this code. Offenses which are not which are or in the future may be punishable under special laws are not subject to the provisions of this code. This code shall be supplementary to such laws unless the latter should specially provide the contrary. So, the revised penal code understands that our our House of Representatives, our Senate, that will continue to enact laws, and some of them may actually be considered as a special penal laws or laws which are related to criminal laws as well. So the our Article 10 provides for such an arrangement or such concept wherein just in case the Senate, the House of Representatives enact laws pertaining to criminal laws, they are no longer subject under the provisions of the revised penal code unless such law enacted actually provides that they will be subject to the revised penal code. So take note of this. This is also a very important concept under criminal laws. So examples of special penal laws, we actually have so many examples of special penal laws. Um, and we continue to our legislative branch of the government continues to enact laws pertaining to criminal laws. For example, Republic Act number 10175, an act defining cybercrime, providing for the prevention, investigation, suppression, which and the what on the cybercrime, uh or on the commission of cybercrime. So, Republic Act number 10175. So, take note of that. I've already mentioned many times before that, again, please refrain from posting any defamatory remarks against any person in the World Wide Web or any other places in the cyber world, because you could be held liable for penalties under the cybercrime law. Republic Act number 9995, an act defining and penalizing the crime of photo and video voyeurism, prescribing penalties therefore and for other purposes. So this is more related to video recording or taking photographs of persons without their consent, especially when they are in a situation wherein or in a scandalous situation. So they also have their rights to their privacy. So if you if you take a video of them without their consent, then you can be held liable for photo and video voyeurism, even if you actually have a relationship with that person. You cannot easily take a picture of such person without his or her consent. And also, you cannot spread such video recordings. You cannot cause it to be published anywhere without the consent of such person. Republic Act number 9775, Anti-Child Pornography Act of 2009. So this is already self-explanatory. So in relation to pornography of children, promotion of pornography of children, distribution, publication is also prohibited by this special law. Republic Act number 9516, an act further amending the provisions of Presidential Decree number 1866 as amended, codifying the laws on illegal and lawful possession, manufacture, dealing in acquisition or disposition of firearms, ammunition or explosives, or instruments used in the manufacture of firearms, ammunition, or explosives, and imposing stiffer penalties for certain violations thereof and for relevant purposes. So take note again, in the Philippines, the carrying or the authority to carry ammunitions and explosives is a mere privilege and is not a right. So you must get the proper authority, the proper license before you can actually carry these types of firearms. So being future police officers, so I hope that you also know this. You are not allowed to carry any type of firearm without the proper license and proper authority. Republic Act number 9346, as I mentioned, an act prohibiting the imposition of death penalty in the Philippines. So as I've mentioned several times already, the death penalty was not removed in the revised penal code. However, our laws provide that as of the moment, courts are prohibited from imposing death penalty even if the crime committed by the perpetrator or by the accused actually provides for the imposition of death penalty. Otherwise, our courts are mandated that instead of imposing death penalty, they may downgrade the penalty to correctional penalty such as reclusion perpetua or life imprisonment. We also have Republic Act 9262. This was very controversial during our discussions the last time. An act defining violence against women and their children, providing for protective measures for victims, prescribing penalties therefore, and for other purposes. So again, this law is still very effective, and I continue to remind all our men that, again, if you have any relationship, romantic relationship, if you've been married with with a woman and you have a child with another woman, there are certain obligations that you have uh to also uh pursue, and of course there are certain protection provided for women and their children under this law. Republic Act number 9208, an act to institute policies to eliminate trafficking in persons, especially women and children, establishing the necessary institutional mechanisms for the protection and support of trafficked persons, providing penalties for its violations and for other purposes. An act amending Republic Act number 9160, otherwise known as the Anti-Money Laundering Law of 2001. Republic Act 9165. So this is also a very important law. We will also try to visit this. Comprehensive Dangerous Drugs Act of 2002. Republic Act number 9160. No, so this was already amended by Republic Act 9194. Republic Act 8505, Rape Victim Assistance and Protection Act of 1998, Republic Act number 8353, Anti-Rape Law, Republic Act number 8049, Anti-Hazing Law. So if you join any fraternity or any brotherhood or any type of organization, sorority, just make sure that you're not involved with any hazing, because hazing is penalized under special law. So if you still remember our discussions on crimes mala prohibita, no? Again, good faith is not a defense. In special laws, good faith is not a defense. Republic Act number 6981, Witness Protection, Security, and Benefit Act. So this is more on the witness protection program. So actually, these are just examples of our special penal laws or laws in relation to criminal laws in the Philippines. So we will visit some of them, especially some of the important ones, of course, on the non-imposition of the death penalty, 9165, BAUSI. So we will discuss more on that as we go along on our discussion under the revised penal code Book 1. So that's it for today. I hope you learned something from our discussion. Take note, we will have our exam on Friday. So be ready. I hope you have taken down notes during my lecture today. So definitely all the things that I've discussed here will appear in our exams on Friday. So I will be seeing you on Wednesday so that we can have a review, a short review of the coverage of our exams for the preliminary exams. And also we will be conducting a recitation for all the topics that we've already discussed, beginning on the definition of criminal law. And of course, the basic characteristics of criminal law. Please do not forget those concepts because they are very important principles, and they will continue to appear as we go along, as we try to understand criminal laws in the Philippines uh, in the future. So thank you so much for today. I hope you will do well on your exams. Do your best, study well. The exam will be difficult. I will make sure that it's going to be difficult because I want you to prepare. I want you to be prepared for your other exams. So make sure that you are always taking down notes. Make sure that you are always listening and attentive during our discussions, and make sure that every time we meet in the Zoom meeting that you will always participate in the discussion and in the recitation, so that if ever your exam results will not be as good as you would expect, then your recitation and your participation, your attendance may be able to augment your grades for the semester. So anyway, this is Attorney Michelle. Thank you so much for listening today. I hope that you will have a safe and healthy day, and see you on Wednesday for our review. So good evening, everyone. Stay safe and stay healthy. Some of them, most of all of them are employees uh, of the country to which they are citizens, and they are deployed to another country para liwat hirata ato dito ka embassy. No, so ito. Hirat nagpa-process it mga visa, ito mga tourist visa, kung ano pa man ito nga mga visa. So itera iton function is more on commercial, no? Diri na hiya more on diplomatic relations. Diri hiraan hidinhi ha Pilipinas para mag-maintain hin diplomatic relations, but aanira din ha Philippines. Kaya may ito nga, may da mga administrative concerns such as the issuance of visa or certificate of visitation, mga saga dito. Okay? So again, a consul is not entitled to the privileges and immunities of an ambassador or ministers. Okay, so we are not now done with generality. So as a review, no, the general principle is that criminal law is binding on all persons who live and sojourn in the Philippines. So ano concept of generality? So dapat it is general to all. It should be applicable to all except for certain exemptions. So syempre may ada exemption. So the general rule, criminal rule, should be general in nature and should be applicable to all except for certain exemptions such as the USRP or US and the Republic of the Philippines basis agreement, the visiting forces agreement, laws of preferential application, no, and Republic Act number 75, no, and other principles of international law. So we are now done with generality. Now let's go to territoriality. So territoriality provides that criminal laws undertake to punish crimes committed within the Philippine territory. The principle of territoriality means that as a rule, penal laws of the Philippines are enforceable only within its territory. So the general rule here, when it comes to territoriality, dapat an crime or felony should have been committed inside the Philippines, 'di ba? Again, dapat an crime committed should be should have been here inside the Philippines. That's why kung Filipino citizen ka, nga nangawat ka ha United, kumadto ka na ha United States, for example, turista ka dito ha US, no? Nangawat ka dito, dili ka pwede kasuhan hin theft dinhi ha Philippines. Kaya di mo commission or omission dito man ha US. So dito ko, it may jurisdiction hito dida is the United States of America. So, extent of Philippine territory for purposes of criminal law, no? So again, adi naluwat kita. Maya the general rule. Now, the general rule is this one. Ang meaning nga adi didi. Number one, criminal laws undertake to punish criminal crimes committed within Philippine territory. But again, we have exemptions. Permit to may the exemptions to the rule. No? So, Article 2 of the Revised Penal Code provides that the provision of said code shall be enforced within the Philippine archipelago, including its atmosphere, its interior waters, and maritime zone. Article 1 of the 1987 Constitution provides that the national territory comprises the Philippine archipelago with all the islands and waters embraced therein and all other territories over which the Philippines has sovereignty or jurisdiction consisting of its terrestrial, fluvial, and aerial domains, including its territorial sea, the seabed, the subsoil, the insular shelves, and other submarine areas. The water around, between, and connecting the islands of the archipelago, regardless of their breadth and dimensions, form part of the internal waters of the Philippines. So, this is a very important definition of Philippine territory. Added to aton Article 1 of the Philippine Constitution, what are the metes and bounds of the Philippine territory? Amin it api. So, imagine, no, pati it kalangitan, that is part of the Philippine territory, and no aircraft could pass through our our aerial domains without the without the approval of our government, no? So yun. So exceptions, dinaluwas kita ng exemption. So again ha, I am repeating this again because this is a very important concept. The general rule, criminal laws undertake to punish crimes committed within Philippine territory. Pero we also have exemptions to the territorial application. Sige daw, ano ni nga mga exemptions? Dito Article 2. The Article 2 of the Revised Penal Code provides that its provision shall be enforced outside of the jurisdiction of the Philippines against those who. So, adi na. Ang first statement, Article 2, Revised Penal Code provides that the provisions of said code shall be enforced within the Philippine archipelago, including its atmosphere, its interior waters, and maritime zone. However, the second paragraph of that article provides that its provision shall be enforced outside of the jurisdiction of the Philippines against those who. So adi na, pwede nga yung gumawas bisan dirigin commit din hiha Philippines, pwede gihapon magkaadahin jurisdiction or right to try the case an aton country and aton domestic courts and aton regional trial court or an aton municipal trial court kung ini nga mga violations ig-commit hit usa nga tawo, no? Siyahan should commit an offense while on a Philippine ship or airship. So ini hira mga eroplano, no, or barko. So if they are flag bearers, vessels, no, for example may barko nga ginrehistro din niya Philippines tapos naglalayag na hiya nakadto na hiya Atlantic Ocean then nagkamay-adahin piracy may nagkasaka nga mga pirate hito nga barko then because of that may ada mga nagkamatay nga mga tripulante. So because the ship is a Philippine ship, bisan pa ang piracy was committed in the high seas, take note ha, walay tag-iyat high seas. Walay ito nagtatag-iyat mga it high seas. Kung ano ito ya, for everyone ito ya, pwede gumamit ito didat. Ito kadagatan, kahaladman, no? So, bisan pa nakatunera high seas or even nakatunera outside han territory han Philippines, kay an ship nga gin pirate, ang ginsak-an han mga pirates, kay Philippine airship man, ito nga mga pirates pwede hira kasuhan din ha Philippines or an era country where they are from pwede kasuhan. Okay? Ikaduha, should forge or counterfeit any coin or currency note of the Philippines or obligations and securities issued by the government of the Philippines. And I'm reminding you of this one ha, kay this is very important. May dapala na dako pwede ha TikTok. Kay ano, actually, it pag counterfeit hit money, no, diri, even if dito here, ginhimo ha ibang nga lugar like China, ha, Taiwan, or whatsoever, tas ang money is Philippine currency. Karong sigon kwarta din na Philippines. Regardless kung diin pa at hiyagin himo, that can still be tried here in the Philippines. Kay it involves Philippine currency and it is one of those cases where uh, bisan an omission or commission was made outside of the Philippines, pwede gihapon hiya try din hi. And please, please, ito nga ni nga mga tampering ni hit mga coins, ayaw niyo pagbubag daw. Ayaw niyo pagtunawat mga coins, ayaw niyo pagsunuga, it kwarta. Kaya ano, because even if we have possession of the money, it's not ours. It always belongs to the Philippine government and there are certain sanctions on that. Bisan nga nit pagsusurat ha kwarta, diri gihapon ito pwede. Bisan nit pagpilo-pilo, overfolding to the point nga nakukunot na kwarta, may da ito mga penal sanctions, pwede ito magkamay-ada ng criminal liability. So, yan na, gini-remind ko ka mo, never do that ha, kay may da ito yan na palagin dakop kay hira TikTok. I don't know what they were thinking. Nagsunog hirahim 20 pesos. 20 pesos lang nga nito, but that's a big no-no under our laws. And what can we do? The law may be harsh. Even if it's only 20 pesos, the penal sanction is actually up to 12 years. Imagine, nagsunog ka lang 20 pesos, pwede ka ngayon maprisuhin 12 years. So I'd never do that ha. Never tamper, never forge, never never destroy Philippine currency. No? Ikatulo, should be liable for acts connected with the introduction into the Philippines of the obligations and securities mentioned in the preceding number. So kung hino man ang nagdarahito dinhi ha Pilipinas nga mga counterfeit money, even if dirihiya siya ang naghimo, no, pwede gihapon hiya maging liable. Bisan hiya tikang ha ibang bansa. Ikaupat, while being public officers or employees should commit an offense in the uh, exercise of their functions. No, so ano man korek sigon hini. So again, kung may nakita mga officers ha ibang bansa, of course, exempted ang ambassador, di ba? Nakanumdum ka man mga exemptions. Pero kanang mga ordinary employees like consul gihapon didto ha ibang bansa, no? Ang aton Filipino consul ha ibang bansa nag-commit herahing crime in relation to their official function, even if they committed such crime outside of the Philippines, pwede gihapon hera i-try din ha Pilipinas, no? Should commit any of the crimes against national security of the law of nations defined in Title 1 of Book 2 or of the Revised Penal Code. So, security in the law of nations, for example, piracy, because piracy is a borderless crime. So, anywhere in the world, basta kung diin ito hiya, kung ha usa nga flag bearer nga ship hiya gin committed piracy, so bisan pet hiya didto na katuktukan hiton Antarctic, Arctic, Atlantic, kung ano pa man ito nga mga ocean harayon na duro Filipinas, if it is committed against a Philippine airship, then it is still punishable in the Philippines. Okay, so that is the territorial applications. So again, ano to? One basic characteristic of criminal law is that territoriality. Ano the territoriality? General rule is that crimes are punishable if they are committed within Philippine territory. But there are certain exemptions. Anong exemptions? Ada ha Article 2 of the Revised Penal Code, amo na ito na akong usa-usa kanina, 1 to 5 ito hera. So do not forget that. If you can, take a picture of this one because definitely I will ask this again during our recitation on Wednesday. Okay, now we are on the last leg of our characteristics of criminal law. Prospective. Ano't kareg signun hini? That a penal law cannot make an act punishable in a manner in which it was not punishable when committed. So if you still remember your ex post facto law, no, nga makes an act criminal that during the time that it was committed, it was not actually defined in a certain criminal law. So dapat permit waray retroactive at karag signon waray retroactive application permilet hiya prospective anat karag singon retroactive. Again, no, for example, an usa nga act is not punishable under any specific law, pero suddenly may ada law nga gin-enact and aton legislature nga and law will punish all acts committed from 50 years ago. Dirito pwede. Kaya di ba, ex post facto law hiya. So the general rule is that laws should always be prospective. So will apply from today and then onwards, never backwards. No? However, again, there is an exemption. So, as provided in Article 366 of the Revised Penal Code, crimes are punished under the laws enforced at the time of their commission. So, kung ano ang mga balaod, hadto nga time, no, amo lang applicable. Kung wala balaod nga nagpa-punish ito nga act, then that act cannot be punishable. No, diri ito sa nga tao nga nag-commit han act, pero diri man hiya defined in a criminal law, specific criminal or penal law, dili iya pwede kasuhan. Kay ano mat ikakasuha iya? Kay waray man crime in the first place. Kay waray man criminal law nga na-punish ito nga act. No, for example, before wari kita tinatawag nga VAUSI. 'Di ba? Wala kita violence against women and children. So, ang mga victims of VAUSI, ano ra to usually gin-file is physical injuries, no? So, diri hiya VAUSI. So, ang VAUSI liwat, diri pwede mag-apply han mga previous nga mga cases kay prospectivity hiya. From the time la kung kakano hiya gin-enact, onwards na an application. So, backwards, wala filing hin VAUSI. Okay, so exemptions now. Amo ito't paborito ang mga balaod. Ano? Kaya pero kung may mga exemptions, makuri na nga ni pagmemorya ang general rule. May da pa ngayon exemptions gihapon. No, so, exemptions to prospective application. Whenever a new statute dealing with crime establishes condition more lenient and or favorable to the accused, it can be given retroactive effect. So imagine this rule, no? It's very, very, it's very, it's always for the accused talaga. No, when we talk about criminal law, when we talk about rights, constitutional provision, it's always for the rights of the accused, no? Whenever a new statute dealing with crime establishes conditions more lenient or favorable to the accused, it can be given a retroactive effect. Ano man karayag signon hito? For example, may ada kita murder case, no? Murder case. So murder case, punishable ito by reclusion perpetua. So reclusion perpetua, pag reclusion perpetua kasi iton iton kaso diri kita basta-basta pwede mag-post in bail, 'di ba? Kay it's a matter of discretion of the court. So depende ha court kung susugtan kita nira mag-post in bail. And then suddenly example lang ni ha this is not diri ni law yan na. I'm just stating this as an example. For example, onwards nagkamay-adahin balaod nga itong reclusion perpetua nga mga cases pwede na mag-post in bail anytime. Diri na hiya discretionary ha court pananglitan la ha. For example ha, direct naya ka nga may ada na hini nga balaod. But just in case in the future, magka may ada sugad hini nga balaod, pwede tiya retroactive application. So, may ada mga murder cases from before of the effectivity of the new law nga allowing bail even if uh, crimes punishable hiya by preclusion perpetua, applicable hiya backwards. Pwede apply han maging kasuhan previously for murder. No? So, amo ito tinatawag na lenient or more favorable to the accused. Kung ano, mas makakagaan para hit accused. Pwede hiya tagaan hin retroactive effect. Pero kung unfavorable hiya para hat accused, wala ito retroactive effect. Always prospective ito. It iya. Kung for example, ang reclusion and instead nga reclusion perpetua himuon nga death sentence na ano, so prospective na ito. Ang mga may kaso before hin murder, iga-apply ha ira is still reclusion perpetua. Diri iga-apply ha ira that that sentence, no? So that is an example of that. But again, there is an exemption to the exemption where the new law is expressly made inapplicable to pending action or existing causes of action. So for example, ang bago nga balaod, hiya mismo dito ha iya provision sa iya stipulations, may ada mismo nakabutang nga hindi nga balaod ma-apply lahiya ha na or diri hiya ma-apply ha mga pending nga mga cases. Ma-apply lahiya han mga mahihimo pa lang ang mga case, no? So, pwede ito, mismo ang balaod and magbutang nga direhiya, warahiya retroactive effect. Ikaduha, where the offender is a habitual criminal. So, habitual punished for the same crime twice under the same title. So, for example, bisan pa ito hiya favorable to the accused pero hiya accused kadamo na makapatay hin tawo diri na ito ay ga-apply kay habitual na hiya permi na lahiya naghihimo hito nga mga sala or nga mga crime. So again, that is an exemption to the rule again, no? So the general rule on prospectivity dapat onwards la permi forward. Always moving forward it aton laws. But if it is more lenient to the accused, then it could be given retroactive effect except or if the law itself makes it does makes it prospective. Ang law mismo ang nag-declare nga diri pwede retroactive application or if the offender is a habitual criminal. Okay? So, different effects of repeal of penal law. If the repeal makes the penalty lighter in the new law shall be applied. Man o kung mas habubo na ang penalty, then the new law will be applied. Except when the offender is a habitual delinquent. Again, utro-utro lang ito niya ginhimo nga mga crimes. Or when the new law is made not applicable to pending actions. So, amo na ito natin exemptions nga state kanina. Ikaduha, if the new law imposes a heavier penalty, the law enforced at the time of the commission of the offense shall be applied. Again, if this is not lenient to the accused or it is not favorable to the accused, then it cannot be given retroactive effect. If the new law totally repeals the existing law so that the act which was penalized under the old law is no longer punishable, the crime is obliterated. Imagine, no, for example, kung diri na ngayon, for example, BP22, issue one sin bouncing check. Ano't bouncing check? Bouncing check is naghimo ka hin cheque, nag-endorse ka hin cheque, pero ito nga cheque, wala ngayon pundo dito ang bangko. Tapos pagkadto ito nga imo gin-endorsean ng cheque, ma-claim na hiyahan funds, wala ngayon pundo, then that's considered BP crime punishable under BP22 or the bouncing check law. Pero what if mag-enact hin law repealing? Diya ka nga oy diri na ni punishable hin crime kay kuan man la ito. Ano pa? Diri man talaga heinous, no? Diri man hiya vile no? So tanggalon ta na lang ni nga BP22 barak magyakan ha anay. Klarohon ko la direk nagyayakan nga tanggalon na ito. I'm just setting an example here. So for example in the future nagkamay adahin balaod nga waray na BP22 i-repeal ta nala the crime is obliterated. So if may ada persons nga accused for that BP22 while ongoing in trial, pwede, pag gumawa ito nga bago nga balaod, pwede hiya ma-acquit, i-obliterate, madi-destroy, waray na kaso. No, kay may na bago nga balaod, nga diri naging kikriminalize ang BP22. That is, if may ada na balaod, waray pa hahastaya na criminal offense lagi hapon or crime lagi hapon, it pag issuehin cheque nga waray pondo. Okay. So, okay, so that ends our part 3 of our discussion on characteristics of criminal law. So generality, as a review has generality, territoriality, and prospectivity. So I hope you understand the basic concepts that I taught you today. No, so please continue to review the discussions that I have stated today. Kai, we will have either a quiz or a recitation on Wednesday. No, so I would require you to do a recitation or a quiz on Wednesday. So please review. If you have the time, mas mabay kung kadamo niyo kitaon, ini nga akon presentation. This will be posted in YouTube or this is already posted in YouTube so you can view this anytime, no, at your own convenience, but just make sure that you are ready for recitation by Wednesday. So that's it for today. I hope you learned something from my discussion. Next week, we will be discussing part 4, construction of penal laws. So how does the courts of the Philippines construct or interpret the laws or criminal laws? So yan na masasabtan na naton ini nga mga concepts. Papunta pa lamang tayo sa exciting na part, no? So it's becoming more and more exciting, and as we go along, damo pat aton maadman. Just please listen to what I am telling you and take time. No, take the time to read the discussions. Take the time to read the notes that I am giving you because I will not give you questions that are not discussed or not given in the review notes. So anyway, that's it for today. I hope that you will always be safe and healthy wherever you are. So for the meantime, no, just study and take down notes from the presentation that I have given you, and I'll see you on Wednesday. So bye for now. God bless to everyone and keep safe.